So we have compared DPDP Act with the GDPR, the European law. Today we are going to talk about some comparison, similarities and differences in the applicability, the way the data is being processed, and about user rights between CCPA, the Californian law, with DPDP Act 2023. Welcome to my YouTube channel where you daily see new content on data privacy. Let's talk today about comparing CCPA, the Californian privacy regulations, with the Indian DPDP Act 2023. So we start with the applicability and scope. Indian law is very clear. If you are processing personal data of an Indian citizen, or if you are processing personal data in India, then you are liable to be compliant with the privacy norms set by the DPDP Act 2023. Even if the data was collected manually, but if it is being processed in a digitized format, that is, it has been digitized after collection, then you still need to you still cover under the norms of the DPDP Act. It could be any business, any size of business, no revenue threshold, you have to do it. California, on the other side, applies their privacy regulations only if you are earning money out of the personal data of the citizens of California. Now, this could be online or offline when it comes to California, but if you are earning money out of personal data of the citizens, then in California, you are also liable to be compliant with their norms of data privacy. It applies to businesses, it applies to service providers, it applies to third parties also, right? There are revenue thresholds like 25 million of gross revenue or earning 50% plus revenue coming out of selling and sharing of personal data only, right? So there's a revenue threshold as against the Indian law, but it is applicable only if you are making money out of using or selling or sharing the personal data of your customers or your individuals or principals from whom you have collected the data, whether it is online or offline. India says online only. As far as legal basis of processing is concerned, like several other regulations, even DPDP says you need an explicit consent from the data principal to be able to use this data. California, you have pick up a database and start using it. Give a mechanism to opt out. Right? People can log in and say, I want to opt out of your marketing thing. But you don't need a consent from them to even start marketing thing. Without consent in India, there could be legitimate users. For example, employment, state functions like healthcare researches, emergencies, you are running behind or doing a surveillance for some terror-related activity. Then in all those cases, then it is a legitimate use. In California, the legitimate use also needs a contractual necessity or compliance, right? Legitimate business interest. Opt-out, India does not sell personal data. There's no of selling personal data officially as such. And in California, you are selling personal data. So you allow people to opt out if they don't want you to sell their personal data. And regulations, sensitive data handling is for children, 18 years. California, the sensitive data is not specifically defined, and but the children less than 16 years age, right? As far as user rights are concerned, right to access data is available for both of them. Right to get their data corrected is available by both of them. Right to get their data deleted from your database, from the marketing organization's database is available in both the cases. And in India, there is no specific mention as of now on right to data portability. But California allows right to data portability, which means you can go to your provider and say, I want my data in a computer readable format. And once he provides you that data, then you can port it or give it to any other provider for them to use the data. To continue with this, right to opt out, not specifically mentioned in Indian DPDP Act, but the base premise in California is you pick up without a consent and allow them to opt out. Now, when we say it is not specifically mentioned in Indian DPDP Act, one way of doing this is to right to withdraw consent, right? So it is not directly called opt out, but if you withdraw your consent, it's as good as opting out. Right to restricted automatic decision making, again, nothing specific in India, but yes, AI and automated decisioning profiling is done in California. And for children, as I said, parental consent in India is 18 years. Parental consent in California is on 16 years of age. So this is some basic comparison as far as the basic applicability, rules, user rights are concerned. In the next video, we are going to talk about the enforcement and the penalties that differences between these two regulations. I hope you like the content of the video. Please press the bell and the like icon. Subscribe to my YouTube channel if you have not already. Thank you.